go.
So we have reached the last panel. For me, the most important one. The reason for the time was that the Master of the Rolls will join us for a keynote speech at 5:30. And I have the pleasure to welcome to the High Commission of Cyprus Professor Adrian Zuckerman, Sorabji, and Masood Ahmed. Before we start the discussion, I should also say that Julinda Beqiraj from the Bingham Center for the Rule of Law couldn't be here because of health issues, but we also have Theano Christodoulou, who is the head of civil justice of the Attorney General's office in Cyprus, who will take the floor first virtually to say a few words and her view about the recent reform in Cyprus in the area of civil justice. And then we will excuse her and we will continue the discussion with my esteemed co-panelists. So, hi Theano, apologies for the delay. Just to say, to set the background, Cyprus is under judicial reform. We have had new civil procedure rules since last September, which is very much similar to the English ones. It has been drafted by a committee led by Lord Dyson. The most important problem that the Cypriot justice has been facing is the severe delays. Average time of adjudication is around 7 to 8 years. Despite of the new rules and some other structural changes, the delays persist. I would like your view mainly on three issues: on the use of technology, on small claims, and the ADR, please.
Thank you, Nicolas. Good afternoon, everybody. Thank you for this invitation and for this opportunity to address our distinguished speakers. Professor Zuckerman. Zuckerman on civil procedure is my what I use the last, I don't know how many years, trying to being a member of the committee working with Lord Dyson drafting the new rules. Dear participants, I would just like to mention a few things, and I will need to be excused because of another appointment I have in a few minutes, actually. Looking at the subject of this panel, the justice system checks and balances in Cyprus, is English common law relevant? That would be a very, very easy answer. Yes, it's in our law, it's in our constitution that English common law is what we use when we have a gap. I've been asked to speak about the reform specifically and a few issues. I would ask Nicolas if I could mention a few other things that I think are important in understanding where we stand. Yes, we do have the new rules of procedure in place. They affect cases filed after the 1st of September 2023. Before these, our rules of procedure were the equivalent to the 1956 English rule of procedures. That was the main text we used. Now, the new rules are based on the 2018 English rules of procedure. So I feel I need to notice that the white book I had in my office using was the 1956 white book. that was available and popular in the Law Office of the Republic Library. And we now use White Book, Green Book of 2018 and afterwards, and of course, Zuckerman on civil procedure. So yes, English common law is very, very, very relevant. It is guiding us through the new rules and how we will apply the new procedures. I could not outline, of course, all the new rules. I will discuss a few things that Nicolas has asked me to address, but also a couple of other points, if I may. Unavoidably, we are facing huge issues in Cyprus, mainly, in my opinion, mentality issues, because that's why I had to put the background that we were using 1956 rules of procedure and now the 2018. So it's a huge gap we have to cover. Adding to those problems, I should say the backlog of cases, which is huge, which means that in some cases courts have to use, and lawyers, the old rules, in some others, the new rules, the Supreme Court issues orders trying to that affect the older cases, but it is difficult because they have been filed in with different pleadings. So it's a bit really difficult now. I will refer to certain main provisions, major changes, and that's the pre-action behavior, which was something completely unknown in the civil procedure rules in Cyprus. It's a novel procedure for us. And we as an office, the law office of the government, we had to establish a small new structure working on those horizontally in the office. In my opinion, the way the rule is drafted does not make their use compulsory, but that's not the idea. That's a drafting issue, and I'm not going to go into that now. Of course, what it said is that if pre-action procedures are not used, the court may impose mainly financial sanctions. Cyprus mentality, because I need to repeat that it's a mentality issue also in Cyprus. When a may is read in a rule, it's usually read in a lenient way. We shall see, of course, how this will be covered by the courts. My experience from practice, I'm a practicing lawyer for the last 30 years for the state. Now, the last few months, as an office, we have received protocols. We have not received actions without a pre-action protocol, unless there were interim measures. So it seems that they are going to be used. And that brings us in the ADR issue, because our rules provide that the pre-action procedure pre-action procedure provides that there should be an effort to settle the claim or eliminate the issues that should be discussed before the court. At the same time, there is a proposed amendment of the law on ADR in Cyprus, so that ADR is made compulsory for cases up to 10,000. And if one does not go through this procedure, for which he has to pay a minimum amount, he cannot file an action before the court. This might raise some constitutional issues, actually. We have addressed them. It's still under discussion. So I wouldn't like to say more on the law, but it does come and coincides with what the rules need to cover. We do have some procedural issues there, so it is still under discussion. So I wouldn't want to go into the details. We did have some problems with ADR in Cyprus. Again, a mentality issue, because up to now, the result of ADR was not binding, legally binding in any way. So Cypriots who would not easily accept a result not favorable to them, that practically meant that all the time and effort spent sometimes meant nothing. They ended up in court trying to solve their case from scratch. The new proposal provides for a procedure whereby the result of compulsory ADR becomes binding. upon an agreement. As I said, I don't want to say much more on this because it is still under discussion. I do have strong personal views on various aspects. It has been discussed on various fora, and the legal and political views do not necessarily coincide on this. So I think it's premature to say more. Since I'm a public officer representing the law office of the government, which is at the same time the legal advisor of the political body promoting this proposal. So if you allow me at the moment, I do not want to say much more. Maybe once there is a final decision on this, we can again get together and discuss it further in another meeting. But now, actually today I was in a meeting about a huge contract, and again ADR came there, and we were discussing it. As an office, we do think ADR could be the only way forward in certain issues, but at the moment, as the law stands, we cannot say much. Apart from the above, of course, the new rules do promote ADR. During case management, the code will help the parties to go to ADR. We do not have any cases or anything to help us by now. For example, what happens if the parties do not want to go? They're negative to that. So we do not, all this is very, very, very new, and we haven't had the chance to have common law, something, a case law to help us and be able to discuss it further. I don't know if that covers the ADR issue, and I will mention a few things about small claims, Nicolas, if that's okay. When I was a very young lawyer, many, many years ago, there was in force a procedure to solve claims below £5,000 for reasons I don't know, I'm not aware of. This procedure was abolished, I might say. And for years and years, all claims were filed under the same procedure. So same procedure, even you were pursuing millions or 300 euros. So a claim for 200 euro could take several years, as Nicolas said, 7 and 8 years, because it was finally decided upon. The last few years, actually, I think it was 2015, there was a fast track procedure, one of the very, very, very few amendments to the rules of procedure we were using, similar to the one now into the new rules. Admittedly, it has worked, gave results in a few months. It was a written procedure, plain procedure, no hearing sometimes, no witnesses, experts or others. The provisions were very, very, very similar to what we're discussing now. I do know that in the English rules, there are 3 procedures: small claims, fast track, and normal procedure. Correct me if I'm mistaken. In Cyprus, it is too early to discuss a 3rd procedure. They say period litigant, in my view, wants his case heard with all his witnesses, and I suspect that unless strongly advised otherwise, the alternative provided that any small claim can be heard as a normal claim will be pursued. On the other hand, we can be positive and believe that if the previous fast-track procedure was used and had results, why not now? Again, we shall see. All this is very, very new to us, and we do not have case law to help us. We do not have practice directions. I am in the standing committee of the Cyprus rules, and a few things do come to our attention. Mainly, they have something to do with drafting, but I'm sure that practice directions will help us eventually if the Supreme Court decides to help with that. Now, Nicolas has asked me to mention something about the technology. Of course, the new rules do have a provision for the use of technology. But but until recently, there was no structure in court to use the technology, only in some criminal courts for obvious reasons. Recently, I mean, there have only been 2 court decisions I could mention, and one refers to that. It had actually, it referred to, it concerned a case filed under the old rules. Nicolas actually handled this case, and it referred to, and there was a claim, and there was an application to have the witness heard in a video conference. And of course, no, the other lawyer said, because no provision in the old rules. And I'm happy to say that the judge said, you know, we have new rules now, we have modernized everything, we cannot stand and oppose such really practical applications, and because the old rules did not contain such a provision. So it means that judges, younger judges, because it was a young judge, started thinking forward, and hopefully this some provision will start affecting older cases as well. We also had a small interim case on a case management issue where interim measures would affect the final date of the hearing. The court did not accept that, and of course they said the obvious, that you can agree between yourselves whatever you want to do with the interim measures, but the fine, as long as it does not affect the final date. As I said, all this is very new. I try to say as much as I could in a few minutes. I do want to say that for the first time, actually, we have also included in our rules of procedure the EU procedures, civil procedure, small claims, payment order, because we do not have national procedures, say for the payment order, for example, and Cypriot lawyers did not know of them. Now they're part of our civil law book, so they can get acquainted with those and maybe use them more. And we don't know if eventually we might have an equivalent national procedure. I don't have much to say. I don't know if I have covered whatever you needed me to mention. I have a couple of minutes before I have to be excused, and I'm very sorry. I wouldn't like to miss this discussion, but I have to.
You most certainly covered everything, Theano, and thank you very much for joining. You can follow the discussion later on YouTube, since it's recorded. Yeah, you can stay as long as you can, and then you can go. Thank you so much again. So
thank you.
I should say at this point that you know, Cyprus has the paradox that the rules of procedure are decided by judges, not by you know, the executive or the legislative branch. So because of this, I would say that the inaction on behalf of judges, we ended up with serious problems, mainly the delays that we talked about. And at about 2018, we had foreign experts, mainly from the European Commission and the Council of Europe, together with Irish experts, the Institute of Public Administration of Ireland, who prepared a report outlining all the structural problems of the Cyprus justice system. One of the recommendations was to draft a new CPR, and then came the Lord Dyson Committee, who each drafted the new rules, which entered into force last September. As you've heard, the problems persist. It is a matter of, I would say, culture, mainly, but also I think it's a matter of decision making. And I want to ask Professor Zuckerman, how do you deal with this, you know, inaction on behalf of the public service, including you know, the judiciary and the Ministry of Justice? And if you, I mean, how do you remember the English judiciary through the years? And how do you approach them to, be more open-minded, more bold, so that reforms come into play?
Well, firstly, you need to ask yourself, what is it that we expect judges to do? And what do judges do? Judges provide a public service, protection of rights, enforcement of rights, providing remedies for wrongs, redress for breaches of all sorts of kinds, everything, all of which is essential to a system governed by the rule of law. The law has got to be enforced. Where the law is not enforced, is not effectuated, people start thinking, is it worth respecting the law? So they provide a public service. Now, in the provision of any public service, you think of any public service you like, whether it is in transport or health, one of the central tasks of the providers is to adjust resources to demand, because resources are always limited, whatever the system is, however rich a country is, resources are limited, so resources have got to be, the benefit of resources has to be maximized to deliver the best possible service within reason. Not the best achievable, but the best practical service. This is the business of management, not the business of adjudication, the business of management, deciding how to allocate resources, how to adjust the procedure to the requirement of the particular case, and how to ensure that delivery is within a reasonable time. Because in the long term, as in Cyprus or Italy, we are all dead, so it's not worth waiting, really. So the problem has not been with the rules ever, but with the failure of the judicial branch of government to realize they've got to manage, they've got to deliver, not just sitting there deciding the case on the merit, however long it takes, how much it costs. They've got to deliver something that people need and that people want, and from which people can benefit. And the civil procedure rules in 1998, more than a quarter of a century ago, recognized for the first time that management is necessary and provided the judiciary with the tools. What do you do with tools when you know nothing about the profession of management and where you don't understand the compromises that have to be made? You know, time, resources, truth. You can't get everything of the best at within, overnight. So this is something that judges are not trained to do. They don't study this at university. They don't feel responsible. They think there is somebody else out there who would manage and be responsible. And unfortunately, the delivery in this country of this essential public service, although we had the best tools and the best rules and everything, nothing is really complicated. It's not rocket science, all this business. We are not doing very well. And we are not doing very well because we haven't grasped this nettle. We need management. We need somebody to take charge of it, to tell judges who are not up to the task of management that they need to up their game or something like that. And the judiciary and the legal profession generally is very traditional. It has always resisted change of any kind. It even resisted the abolition of the forms of action in the 19th century. So, on the other hand, the judiciary have got a very strong political card, independence of the judiciary. But I think that we should start realizing that this independence shouldn't be licensed for mismanagement. Because you need to understand public services need to be managed. They are managed, but they are managed either badly or well. There is nothing, well, there are some things in between, but until this problem is grasped, we're going to make very little progress. We've made progress, some progress, because there have been some younger judges, more enterprising and so on, but it's not across the board, and it's not, we've made progress in relation to time, the duration of reaching a final judgment has come down, but the cost has gone up, so we haven't achieved that objective, which is one of the objectives of the CPR of delivering adjudication at proportionate cost. So what is the advice that I would give Cypriot policymakers? Whatever you do, don't leave it to the judges.
Okay, thank you. I'll come back, and I want to ask John, John, you have worked with the judiciary, and how can you convince a judge to, take bold decisions, not, management decisions?
Well, I think, first of all, you shouldn't be trying to persuade judges to make decisions about judicial adjudication or case management. That would be an infringement of judicial independence. That's not the role of a civil servant or a court administrator. So my answer to that would be no, you don't. In terms of how you improve things, you can improve things through judicial training. Judges through the Judicial College here are trained now in what's called judgecraft and have been for the last at least 30 years. I think the Judicial College and its predecessor has been around since at least the 1990s. So training in management, in the operation of the new rules, in the philosophy that underpins those new rules. So you can train them. You also have to accept that, as with any change, particularly when you introduce new rules, culture persists. It takes time to change cultures, and it takes an explanation, and a clear and coherent explanation repeated time and time again before cultures shift. And we've seen that over the last 150 years here. Adrian's already talked about the form of actions and the resistance to the abolition of those. Even when you abolish the forms of action and you put in new procedures, the culture of the forms of action, as it happened in the 1900s, persists. It wasn't until we had fundamental reform in the 1870s, and then only 20 years after that had been introduced, that you started to see a shift in culture. And we've witnessed the same thing over the last 25 years, quarter of a century. Cultures take time to shift. So you introduce management tools in 1998. You have continued, as Adrian put it, mismanagement. Well, an absence of management is another way of putting it, as well as mismanagement. But it takes education and time and new judges coming in and the new culture to embed itself through instruction and through guidance from the Court of Appeal, not from civil servants, from the Court of Appeal, in terms of the interpretation and application of the rules, for management to start to embed itself, and to embed itself in a way which is effective and which is consistent with the new approach that you've got. So I think, in terms of what I would suggest, is accept it's going to take time, accept that you need clear and consistent guidance from your appellate courts on how the new system is supposed to operate, and have judicial training which effectively instructs judges as they're entering into the judiciary, and of course remedial training throughout, in terms of letting them know and understand what the purpose and application of the rules and case management is. And you do that before they get to sit in court, so that you don't have to entertain questions of how do you get them to change their decisions once they're in court, or how do you influence them, because that's improper. You do it before they get into the court, through training and through guidance, through precedent and appellate decision making. So that's what I would suggest. is the way forward. But you have to accept it's going to be a long battle. It will take time.
Thank you. Masood, what's your view in terms of the change of culture? Is that a matter of judges, training judges? Is it a matter of lawyers? Is it a matter of is culture something that changes over time automatically, or do you have to have stricter rules so that culture changes?
Yeah, that's a good question. I mean, I think it's all of those things, to be honest. I mean, I think the issue about culture, I think what John's already mentioned in terms of taking time to change is a very important point, because people are rooted in the way they do things, and that persists, and that exacerbates the problems. And we've seen that over the years, as Adrian has written extensively on how mismanagement of cases through the civil justice system, or poor management of cases through the civil justice system has caused costs to increase and delays to increase and all the rest of it. So I think it's all of those things, and I think one of the fundamental points is the issue of training judges. I mean, John's already mentioned it, but I think this is fundamental because we have a very good judicial college. We have people who come in, academics who come in. David Allred, he lectures to judges. And I think that's going to be fundamental because that's where judges can step out of the court arena and actually engage with people who have knowledge of the area and people outside of the system, whereby they can understand what is actually happening within the real world and to educate themselves on how to approach the litigants that are coming to the civil justice system. So I think training judges and broadening their understanding of the wider issues beyond strict rules and procedure are going to be fundamental. And I think one of the areas in which that can happen is the issue of alternative dispute resolution, because I think that's always been a thorny issue within the civil justice system for a long time, even though Lord Wolfe introduced ADR for the first time in the more formal sense by making it part of the rules. It didn't really have the take-up amongst the judiciary. And I think through the judicial college, that's one way in which approaches to the use of alternative dispute resolution can be enhanced, and not just essentially ordering parties to go to ADR, but actually educating judges on the different types of ADR procedures, engaging in a conversation with litigants and trying to understand the type of disputes and the way ADR can fit those disputes. So I think essentially it's going to come down to really training judges on a different way of managing disputes. Mm-hmm.
Yeah, I should say at this point that Cyprus recently established a judicial school like 5 years ago. John was a speaker in an event right after the School of Judges was established. But I think, again, the training there is not up to standards and not following international developments. But I agree in principle that one of the solutions is that. I want to ask Professor Zuckerman, how do you remember the years right after 1998 here in this country? Was there really an issue of culture? Were you discussing about that litigants, lawyers, judges it was difficult for them to adjust to the new rules? The reason I'm saying this, apart from what Theano said, is that there are a few judgments with the new rules, and judges lightheartedly use the old rules. They're not even, puzzled on the president on old rules. They're not even, even citing the chapter in your book which discusses which president we should use. So how was the situation here? The first 5 years after the new rules were introduced.
Before I come to this, how the situation is, I agree with John. I want to comment on John. He's absolutely right. I mean, he's an insider. He understands the system much far better than I do. And you have to get to the judges to train them before they sit in court. That's the only way of doing it. But it has taken more than a quarter of a century to get anywhere, and we are not there yet. Now imagine that a new kind of medical culture was available to treat cancer. And we said to people, you know, it's difficult to change doctors' culture. Let's wait for 25 years until we put it in. Can you imagine what people would say if we adopted this policy in relation to health? When we know the tools are available now, why wait?
I will use this example.
Now, what I remember is that some judges were very quick to understand what management meant. So, for example, management meant this. If a litigant got a fair opportunity to comply with the procedural requirement, let's say serve some document, make disclosure, say witness there, whatever. If they got a good opportunity, a reasonable opportunity, plenty of time, and they were not prevented by any circumstances beyond their control, they should not be given a second chance. Finished. Go home. You had your day in court, you didn't take it, there are other people waiting here to be heard. And these people understood, but the people in the Court of Appeal, and I can't remember the House of Lords, whether the House of Lords it was or not, they didn't understand. They went back to the old system. Let's give them another chance. Giving another chance, of course. The next chance doesn't work, more litigation about litigation. We went back exactly to where we started. It took another change in the rules to reverse this culture 10 years later. 10 years? Why? Why wait 10 years when the rules were clear from the start? Now, I wish the master of the rolls had been here when I made this comment. I'm always repeat that.
Okay, are you done?
Yes, that's what I remember.
John, I want to ask you, do you have anything to comment on this, first of all? The time right after the new rules were introduced, how things were they very challenging?
Well, I think there are two things that I can say. First of all, in terms of the use of precedent from before the change,
yes.
At least the position that was taken here from 99 onwards was that there was supposed to be no reference. But in a number of cases, there was looking back. And in some cases, it was appropriate to do so because the rule hadn't changed from the RSC to the CPR, and the move to having an overriding objective didn't really make any fundamental difference to how it should be interpreted. So there were cases after 1999 where the courts did properly look back to precedent. So I don't think you can take necessarily as an absolutist perspective on that. Sometimes it will be useful, sometimes it will be necessary, but you have to exercise care.
Yeah, and at least judges should consider this and look for, what other jurisdictions are saying about this, which, like this one, which have tried and decided on what to do.
Well, I think it's always a good idea, in principle at least, to look at what other jurisdictions are doing, particularly where the rules themselves are the same or similar. And I think the approach that, at least in England and Wales, has been taken is that we do look to other jurisdictions. I mean, Singapore is one particularly. I think legal professional privilege and the extent of that has been looked at through the prism of Singapore and developments there in recent years. So absolutely you can look elsewhere. And I suppose one of the things that we could say, and if Lord Dyson were here, he might remember at one point he himself made the point that one of the things that jurisdictions which adopt approaches similar to the CPR is to look at, as he put it, the mistakes that we made when we were implementing it, or in the kind of 10 to 15 years after that. So learn from what we've done as well, particularly if, as in Cyprus, you've introduced new procedural rules which are based on the CPR. So that...
Do you have any, sorry, changing the subject, do you have any comments on, the use of technology and more specifically, video conference trials? Because as Theano said, have only one judgment saying that we should start, doing video conference. What does the experience say? Especially, I think we were discussing this with Masood during COVID. What was, what did the lawyers and the litigants say?
Well, I'm not sure what the lawyers and the litigants said, but obviously during COVID, when it started, there were no rules dealing with it, and there was you could describe it as a mad dash, perhaps, to put in place provision to deal with it. But I think one of the points that came out from the speaker earlier was that there are no rules in your old rules, which are still being looked at, which deal with this. Well, the answer to that, and I think the answer that we alighted on as COVID started, was the court has an inherent jurisdiction to manage its process. And you can rely on the inherent jurisdiction in the absence of rules. But even in the absence of that, it doesn't take very long to create a practice direction. I think during COVID, we were producing practice directions overnight. If the Master of the Rolls remembers that, I'm looking back, he and his private secretary, who are at the back of the room, may well remember the drafting process that went on at the time of that. But you can move quickly when you need to. And the judiciary can move quickly in terms of ensuring that the justice system can operate effectively in times like that. So in terms of using video conferencing, I don't see that as a problem at all, whether you have a rule or not. And if you view it as a problem, then I think you can easily rectify it by using practice directions, which rest on, ultimately, the court's inherent jurisdiction.
Mm-hmm. Thank you. Masood, any comments on this?
Yeah, just one point just to finish off. Collaboration, I think that's a key thing in terms of change of culture amongst the judiciary and moving reforms forward. And I think in our jurisdiction, we've been quite successful in doing that, collaborating with policymakers, collaborating with collaboration between the Civil Justice Council and the Civil Procedure Rule Committee, but more importantly, engaging with and collaborating with the practitioners, the lawyers, who are going to be advising clients, but also the third sector, so voluntary sector and charities in terms of what their needs are, because they are actually dealing with individuals who have those particular problems when they come to the civil justice system. And so I think there are many examples in our jurisdiction where we've successfully done that, and we've used technology as a way to improve access to justice. And one example is, for example, the online civil money claims, which is an online system for people without representation to bring money claims and get a resolution to their dispute. So I think collaboration between the judiciary, the practitioners, and the third sector is fundamental, and I think that can drive important change in culture, especially in Cyprus, where you have these brand new civil procedure rules, but I think it's going to be fundamental that judges understand that they need to work with others.
Mm-hmm, mm-hmm. Thank you. Any final remarks?
Oh, I'd like to listen to Master of the Rolls.
Okay. So, okay.
I've been waiting all this time. We've been just passing the time.
Okay, so we'll conclude here. John, do you have anything else to say? Any other remarks?
No. Far be it from me to kind of stand in between.